Hello friends, welcome to Happy Institute YouTube channel. Happy Institute is one among the leading institutes imparting training in stenography. The institute in the last 35 years has helped hundreds of aspirants of government jobs in fulfilling their dreams. Students of this institute have secured top ranks in various All India competitive exams held by UPSC, SSC, DSSB, IBPS, and other recruitment agencies and are working in almost every department of Government of India, be it Ministry of External Affairs, Railway Board, Home Ministry, Election Commission of India, Income Tax Department, CBI, and other prestigious organizations like Supreme Court and High Court. We also publish happy speed dictations for developing speed with passages meticulously selected from latest topics with practical phrases and simpler outlines. This book has become the most prominent choice of almost every reputed institute, teacher, and student of stenography in a short span of time. The proof of its popularity is that in the last 3.5 years, more than 25,000 copies have been sold all over India. We have now launched a series of legal dictations to help aspirants who have to appear in skill test of Punjab and Haryana High Court on 27th February 2022. The dictation is released every day at 1 p.m. on Happy Institute YouTube channel. The students are requested to write and transcribe this dictation and compare with the original passage given in the description more than once if required. Please like and share every dictation that you write and subscribe to Happy Institute YouTube channel. Get ready for dictation, please. 5 seconds. Start. The facts giving rise to the present petition are that the petitioner had given a check to the complainant, which the complainant claims to be received in discharge of enforceable liability of the petitioner. The said check was defaulted in payment. Therefore, the complainant had preferred a complaint against the petitioner under Section 138 of Negotiable Instrument Act. The complainant completed his evidence. At the stage of starting of the defense evidence, the petitioner or accused has taken a plea that the check in question, though undisputedly signed by him, however, was not drawn by him because he had not filled up the body of the check. To prove this fact, the petitioner or accused moved an application before the trial court for sending his sample handwriting to the expert for comparison of the same with the writing found in the body of the check. That application was declined by the trial court, while the above said order dated 29/1/2019 aggrieved against the order of the trial court. The petitioner or accused preferred the revision petition before the Court of Additional Sessions Judge Faridkot. However, the same was also declined by the Additional Sessions Judge vide order dated 2/7/2019. While dismissing the revision petition, the Revisional Court observed that the accused want to plead that it is not he who filled up the body of the check, rather it is the complainant who filled up the check. However, the complainant has not even claimed in the complaint that the accused filled up the check. Rather, it is the positive case of the complainant that when the check was sought to be handed over to the complainant, at that time the body of the check was already filled up. However, the signature of the accused or petitioner was not there. Therefore, the petitioner or accused was asked to put his signatures so as to complete the check. Accordingly, the petitioner or accused put the signatures on the check in the presence of the complainant and thereafter handed over the same to him. Still further, it was observed by the trial court that signatures on the check are not even disputed by the petitioner. Accordingly, the Revisional Court held that even as per the law, it is not necessary that body of the check in question must have been filled by the accused or drawer himself. The body of the check could have been filled up by anybody. Therefore, this fact is otherwise also irrelevant. While arguing the case, learned counsel for the petitioner has submitted that the petitioner or accused has taken a plea that he has not drawn the check. Drawing of the check means completing all parts of the check by the petitioner or drawer himself. The petitioner could have filled up the check himself, or it should be filled up in his presence or with his consent. It is further submitted that since the accused or petitioner is leading evidence in his defense, therefore it is for the petitioner to choose the mode of proof of a fact. Since the petitioner is to rebut the presumption, therefore he can prove that he had not drawn the check. Hence, the courts below should have allowed the application and thereby should have permitted the comparison of writing on the body of the check with the handwriting of the petitioner to support his contention that check cannot be taken as drawn by the accused if it is not filled up by him. Counsel for the petitioner has relied upon judgment of Orissa High Court. Having heard learned counsel for the petitioner and having perused the file, this court does not find substance in the argument of the learned counsel for the petitioner.